It is just a huge, huge honor to bring back to the show for a second time my only labor attorney I've ever used, John James Balitis Jr., JD. I brought him on 249 days ago, March 27th. I brought you on, and we had that special webinar with you, Chuck Cohen of Benco, Dr. Gordon Christian and his wife, Rella Christian, and Art Wiederman, CPA, George Tykowski, to talk about COVID. And my gosh, I'm bringing you back 249 days later. First of all, it seems like an entire century ago, but I wanted to bring you on for the obvious labor reasons where when dentists start, when someone tests positive, there's a lot of legal implications. Do you close down your office? Do you burn it down to the ground? Do you stay open? I mean, it's just crazy. But in case they didn't catch the first show, you're an attorney and partner with the law firm of Jennings Strouss in Phoenix. I think I started with you when you were with the firm of Ray Harris.
Well, Ray Harris was at Fenimore Craig, and that's how you and I met. Yeah.
Oh, okay. So I met Ray first, then you,
right.
Or did I meet you, then Ray?
Ray first, then me.
So you're just second. You're just second. It
was a hard act to follow, but it worked out, Howard.
Ray is the greatest man. I love that guy. And I love you too. I mean, you guys have just been, and that's what you need. That's what every dentist needs. You have to have a great team. You can't sign a 10-year lease in a building and not have an attorney read the lease contract. How many times have I seen that explode? Dentists always think since they got A's in calculus and physics that they don't need anybody. And what they don't realize is that the people that go the furthest always have the best and strongest team. Just like football. I mean, look what happened to the world's greatest quarterback when he said, I don't need the Patriots. I can go anywhere. Well, he went down to Sarasota, or went down to Tampa.
Yep.
And I think do you think he's probably wishing he was back with the Patriots right now?
Well, I don't know about that, but he sure is pushing out the story about how wonderful his relationship is with Bruce Arians and how he loves his teammates and the organization. Sounds like he's talking probably too flowery about that type of stuff for it to be real, but I don't know.
Yeah. But man, I mean, if you're a great quarterback, it really helps to have Gronkowski, and all these other people on the team. And Lori and I pinch ourselves every day that you're our labor attorney, and Ray Harris literally saved Dentaltown in the beginning. But anyway, so you're an attorney and partner with the law firm of Jennings and Strouss right here in Phoenix. Over his 30 years of practice, he has counseled and represented private public sector clients in all aspects of employment law and labor law. Mr. Balitis litigates employment-related disputes in federal and state courts where he has both bench and jury trial experience and has appeared and argued before the Arizona Court of Appeals. Isn't it something really small, like only like 1% of attorneys actually go before a trial? Isn't it like a really small number of attorneys? Most all settle out of court.
Yeah, litigation's got really expensive, over the past 10, 20 years. And so a lot of cases will either get arbitrated, which is a little cheaper, or majority of them will settle because parties just don't want to spend the money to take a case to trial. So we don't have as many trials as we used to, but once in a while we do, and they're fun. They're great experiences.
But what percent of attorneys after they retire will have never gone before a jury and a trial?
Well, probably 50%, because there's a whole area of legal practice that never involves litigation. I mean, if you're a deal lawyer, like doing mergers and acquisitions, or you're writing wills, or your intellectual property, a lot of times those lawyers are really basically just working from their desks and helping their clients out, and they don't have a litigation skill set. So they would never see the inside of a courtroom necessarily. It depends on what type of practice area you're in.
Yeah. So let me finish your bio. He is also experienced in training, investigating, writing, speaking, publishing, and interacting with the media on employment-related topics and developments. He also serves as an arbitrator, mediator for the American Arbitration Association. He participates in proceedings in these capacities in Arizona and other jurisdictions. And I know I've gotten a lot of backlash before when we put up some courses, a couple of courses on how to prevent being embezzled against in your office, how to stop embezzlement. A lot of dentists demanded that we take the courses down because they said, you just made a training manual that if my assistant ever watched this, you just told her how to do it. And so my gosh, with when we're talking today about how dentists can prevent and, COVID-related claims, I don't want to give a blueprint to the rest of the staff, like, oh, go watch Howard and John. They're going to tell you how to do it. So I'll try to avoid that. But first of all, my gosh, I've got so many questions to start with, but what does it look like as far as a liability? Say someone like me, your own client. I got a dental office. I got a dental media company. What happens if someone catches COVID at either place?
Well, you can sort of break that down into a couple of categories, right? You can have your patients, you can have your staff, and then you can have other third parties that sort of are similar to patients in that they don't work for you, but they're coming into your practice, they're coming into your site. And the liability questions really are different depending on which group of people you are focusing on. For workers, for staff, by and large, if an employee believes that he or she contracted the virus at work, at your practice site, there's a strong likelihood that claim will be considered an industrial injury. So your liability, probably your risk, is fairly low because the whole workers' compensation scheme, theoretically anyway, should probably back you up and insulate you from liability relating to a claim that a worker caught the virus at work, okay? But when you're talking about third parties, whether they be patients, the FedEx guy, the copy guy, whoever comes into your office space, to your site, it changes because you have a different type of duty to those individuals, and you're not insulated by a scheme like workers' compensation when it comes to those people. And I guess, the stalemate in Congress that we've been sort of watching for the past several months about a final or another stimulus bill has really been locked up as a result of a debate about how much protection Congress needs to give to businesses against this precise type of liability. And until we get a law passed on the federal level that answers that question, dental practices, like every other business, need to sort of fall back to some more generic rules. And that is any third party who comes into your space that might contract the virus is going to prosecute that claim like they would a simple negligence claim, like they would a simple car accident claim. They're going to have to show that you didn't act reasonably in whatever you did to protect them. And then they're going to have to show that they actually caught the virus at your site. It's the duty and the causation. Those are the two elements of the claim. And to me, the best way that you can deal with both of those elements is to do what the CDC has been saying for months. And it expects every employer, this of course includes dental practices, to prepare a written prevention, preparedness, and response plan relating to COVID. This thing needs to be in writing. It needs to address all aspects of COVID, all types of scenarios that you may encounter in your workplace, how you are going to either prevent them or deal with them in the unfortunate circumstance that they occur. And if this plan is strong enough, if you've got a good written plan in place, like the CDC says you should, that will go a long way for you to defend yourself in response to both of those things. Did you act reasonably? Yeah, I have a very granular, thoughtful, written plan. And is it likely that the third party caught the virus at your practice site? Well, no, because I've got the plan. I took steps to prevent people from contracting it. I kept the place clean. The plan, it's laid out, by the CDC and guidance that you can find online. We've drafted hundreds of these plans for employers. They each need to be tailored a little bit to each individual business. But the key, I think, to avoiding liability in these cases is really to start with the plan, your written plan. And it'll guide you in everything that you do.
Did you write the written plan for us?
If you have one, I'm sure we either wrote it or we looked at it and probably tweaked it. And I'm sure you guys do. I'm sure you guys have one.
Right.
In fact, I remember, I think I remember talking to Lori about it a few months ago. Yeah.
Yeah, I just assumed when I saw it that you were that you're behind it. I just Googled the bar associations. What percent of attorneys never litigate a trial, and said the majority of the work of a trial attorney occurs outside the courtroom. In fact, only 1% to 2% of all civil cases actually proceed to trial. So that's where I was thinking of the lawyers, but it was actually of the cases. So only
Oh,
1
the cases.
to 2,
Yeah, that's
1
probably
to 2%
probably
of
right.
it.
Yeah.
Yeah, so I was confusing lawyers with cases. So do you think, I mean, asking Congress and Senate, I mean, they're all attorneys. I mean, I've always wondered what our government would look like if instead of all attorneys, it was all like dentists or physicians. I mean, how would it be different? But you guys are doctors of the written word. But it seems to me that a hen house filled with attorneys aren't going to pass a law to take all their money away. I mean, it seems like they'll probably write a bunch of laws so that the 1 million attorneys, cost America about $1 trillion a year out of a $19 trillion economy. Of course, the 1 million physicians cost about 17% of the GDP. But do you really trust a room full of lawyers to take out all their business by passing a bunch of laws that give individual business owners like myself with a dental office and everyone listening to you today, take away their livelihood?
Well, in this particular instance, I do, and this is why I say that. You and me right now aren't talking about tort reform on some huge global level. Congress is never going to pass tort reform at the federal level, I don't think, for the very reasons you described, because putting a cap on damages in personal injury cases and all that sort of stuff, it sort of aligns with the remarks, your remarks, in that you're basically looking at a lot of lawyers really limiting a lot of their colleagues' business on a big scale. All I'm talking about right now is COVID. And what Mitch McConnell says, and I don't know that I buy into this 100%, but he's basically of the belief that unless we create some very specific protection for businesses related to COVID infections, we're going to see an explosion of litigation that is going to just further cripple the economy. And so I do trust, I think that what we probably will see when we see the next stimulus bill, if we do, in terms of protection, is probably something like, not some law that insulates employers or dental practices from liability altogether. Maybe they will create a clear and convincing evidence standard in that type of case. So they would say, in COVID cases, if you're going to sue an employer based on an infection that you think you got when you walked into a dental practice or a grocery store or whatever, you have to be able to prove that claim not by a preponderance of the evidence, which is the standard civil proof. You would have to prove it by clear and convincing evidence. So in other words, it would protect employers because it would make it harder for a claimant in a case like that to create liability for the business. Wouldn't eliminate the claim. It wouldn't reform tort law in all respects. It would be very targeted, and it would just be dealing with this very specific area. And I think if they can get their act together, I think we can trust them to do that. I do.
Okay, well, here I'm going to throw a big storm at you, but I know you can handle it. So this guy's asking on Dental Town. He says, "Okay, I have a small office, just 3 employees. The staff get paid time off for vacation, 6 days. One of the staff members tested positive to COVID after her husband got it. So it's not from the dental office. Her husband got it. So the rest of the staff are negative. But the question is, does the dentist have to pay for the quarantine time off? I mean, if I send you home to quarantine for 2 weeks, you're a labor attorney. Do I have to pay your wages?"
Okay, well, so back in, after this whole thing exploded, April, May, Congress passed the Families First Coronavirus Response Act, the FFCRA. Federal law applies to all employers with less than 500 workers. So the dentist, the practitioner you're talking about right now, his office is covered. He's got 3 people, okay? And there are a whole new set of leave rights for workers who either get infected or who suffer consequences because of a collateral infection that they now have until the end of the year. These are all set to expire at the end of December unless they get extended. But in your scenario, so one of the employees gets it and they are experiencing symptoms, and presumably they're going to go and get a test. Under the FFCRA, if they are experiencing symptoms and they are seeking a diagnosis, those 2 things, they get 2 weeks of paid time off, which is capped. There's a cap in there. And most people are paid more regular compensation than what the cap is. But that person, that staffer that you just described, when they are sent home effectively to wait out the symptoms and get a test, yes, the answer to your question is that dentist would have to compensate that person. But keep this in mind. The way Congress set up this law is that expense is a complete pass-through. It doesn't cost your dentist who asks the question any money. They deduct the money that they pay to the worker from their side of payroll withholding on the next payroll period. So it's a pass-through from the federal government straight to the worker. So it's other than the loss of 30% of this dentist's manpower, which is probably a problem. That expense is not borne by that dentist. It is paid for by the government through that, if you will, really quick reimbursement scheme that was set up in the law.
That is just amazing. And one thing I want to remind the dentist is that whenever there's a question like that, they always say, well, my accountant said this. I'm sorry, is your accountant also a lawyer? But they usually say, well, I called 3 dentists, and they all said blah, blah, blah. And I'm always thinking, well, I wish you would have called 1 lawyer in your own state, because these states are different. I don't think a lot of dentists realize that, you think that since McDonald's is the same in all 50 states, labor law, how much of labor law is different in Arizona than next door in California?
Oh, well, that's like actually probably the best example that you could bring up, because California is the most employee-friendly state in the country, more so than any other state. And it is so employee-oriented. And when you contrast that with the employment law at the state level of Arizona and virtually every other state, it is completely different. It is denser, and it is all focused on the worker. There are so many laws in California that favor the worker rather than the business in comparison to that ratio that you see in Arizona, Nevada, pick any state. So to answer your question, I mean, that was a great example. Just to answer your question, laws like this at the state and local level are very different from state to state. But the FFCRA that we were just talking about, which provided that employee who went home with symptoms and who was going to get a test with 2 weeks of paid leave, that is federal law. So that applies to everybody,
So, I know you for a long time. You're not just a great lawyer, you're a good person, a good man, and you describe their labor laws as labor friendly instead of saying, they're horrible for the owner. How is it in your experience? I mean, you've been doing this for decades. Man, it must be really hard to be the umpire to call it between what's best for the employer, free enterprise business, and what's best for the person, the worker, the human. Those are just tough calls, aren't they? To draw the line? I
guess, except here's the philosophy that I've developed through my experience over the years is that fundamentally all the laws that we have, and I practice in Arizona and Colorado, so I know anecdotally about employment law in other states like California, for example, but we all know the federal law. And all of the laws in my area that protect workers against unlawful discrimination based on protected characteristics, Title VII, the Age Discrimination in Employment Act, the ADA, the FMLA, those are all fantastic laws. Workers should have, and it took a long time, frankly. I mean, the ADA wasn't passed until the 90s. We didn't give, protection to employees with disabilities like we did gender, race, ethnicity, national origin until way after that. So these laws are all important and they all should be there. The problem, though, sort of to get to your question, is for every law that gets passed that benefits somebody and is legitimate, you're going to find a handful of people who are going to figure out how to exploit it. And they're going to take advantage of the law and use it in a way that it wasn't intended. And that's where it gets difficult, because when you see somebody with a valid claim under one of these laws, just because I represent businesses doesn't mean that that upsets me. I think the person, if they have a valid claim, they have a valid claim. It's the people who exploit the law and know how to do it and do it intentionally that creates trouble and expense and waste for employers. You know, so that's kind of my soapbox speech on that. So
the first thing you're saying is that the dentist needs to have a written COVID plan.
Absolutely.
And what if one of my homies is listening right now and he's in another state? Say he's over there in New Mexico. Can you write him one for New Mexico, or should he get a labor attorney in New Mexico?
No, these plans largely are based on CDC guidance. So we would be able to write a plan like this for any dentist anywhere in the country.
Okay, how would he contact you for that right there, right out of the gate?
I would just recommend that he just hops on our website and pull up my profile, and he can email me, call me, whatever he likes.
And that is JSS Law for Jennings Strouss Law.
JSSlaw.com.
Yeah. JSSlaw.com. And then how does he find you when he gets there? What would it be?
Type in line. Just go to B and look for me. Balitis, Balitis.
There he is, John Balitis. Let's see what shows up. There it is. So it's JSSlaw.com/professionals/Balitis-John-J for John James Balitis. So the first thing he has to do is have a written plan, right?
That's right.
And it's got to be written up. So, just jump. And how much would something like that cost on average?
Well, they have to be, each one has to be tailored to a particular business. And a lot of factors, that we consider would be size, how many workers you have, what your physical, site is like, and so on. They're not, and I can't say that we have a pure template that we can just take and insert, the name of your practice and a couple of things and we're done. But they're not costly propositions, Howard. We can do them very efficiently. Likelihood is, though, even with the plan, there's probably going to be some advice that people will want that'll come along with it. We can provide that as well. Because once you get that plan, you're going to probably need a little bit of counseling in relation to it. And we're probably going to cover a little bit of that today when we finish up the talk. But
so the first thing they do is they can contact you and get a written plan. And then you're talking about, duty and causation. Did the dentist act negligent? Did the dentist write out a written plan? Did the dentist act reasonable? Is it likely the person caught it there? And then what steps need to be taken by a dental practice if a reinstated worker reports that he or she has tested positive for COVID-19?
Well, that'll be right at the core of the plan. And the process and the protocol for addressing a situation like that when you have a worker who tests positive is one of the critical aspects of the plan that you will then want to apply in a situation like that. And we could run through real quickly some of the things you need to keep in mind and do if that happens. And what's interesting about them is some of them are kind of counterintuitive. So it's interesting. It's helpful not only to have a plan to protect yourself, but from liability. But I think it helps you think these things through, sometimes in ways that may seem a little counterintuitive. So, for example, if you have somebody test positive, one of the things you're going to immediately have to figure out is who else in the office may have been exposed to this person. And I think intuitively, the first thing you would want to do is go to everybody who works in that person's area and say, hey, were you interacting a lot with so-and-so? And figure out, sort of reverse engineer it to kind of figure out who might have been exposed and who you could predict may have caught it. But the ADA and HIPAA, at a minimum, make clear that you can't approach that situation that way. You have to keep the identity of the infected employee confidential. So the first thing you're going to do is go to that employee, the infected employee, and approach the investigation from his or her standpoint and say, all right, who did you interact with in the office, for how long, and under what circumstances? And then you would go to that group of people, depending on what level of contact they had with that individual, and tell them what they may or may not have to do to address the situation. But you do not identify the infected person, because that, under the law, is, I mean, it may become painfully obvious because they're going to just disappear from the office when you send them home, depending on the size of your workforce. But nonetheless, you must maintain that confidentiality. And one thing to keep in mind, because this is fairly recent, initially when the CDC started talking about who it thought was most at risk if exposed, the CDC guidelines reflected that a person who interacted for 15 or more minutes consecutively with an infected person within 6 feet was at high risk of contracting the virus. And so in the scenario with coworkers in the office, under that guidance, you would be basically trying to figure out, well, who interacted with the infected employee within 6 feet for 15 minutes or more. Those people you would send home to quarantine and tell them to get a test. The other people who may have had just occasional contact with the infected worker, you would allow to continue working in the office and tell them, self-monitor. If you start developing symptoms, then you're going to go home and test. But we don't think you were essentially in that zone that puts you at high risk, according to the CDC. Recently, the CDC revised its guidance, and now they still use that 6 foot distance. But the 15 minutes of exposure time is over 24 hours. It's no longer consecutive minutes. So now if you end up with an infected employee in the workplace who you send home, and you talk to them to find out who else in the office may have been exposed, you're going to want to know, who did you interact with for 15 or more minutes over an entire day within 6 feet? And then those are the people you probably you may want to consider sending home. The other people with occasional contact, saw them in the beverage station, passed by in the hallway, those people you're going to welcome back to the workplace, but have them self-monitor, keep an eye on to see if they develop symptoms, and then decide how to proceed with them if they do develop those symptoms. So the confidentiality of the infected worker, and then how to assess potential collateral exposure within the office. Those are two big things that you immediately need to look at and execute on if this should happen at your practice site.
Wow. I mean, gosh, I know I'm biased, but I can't imagine anything happening like that in a dental office without everybody figuring it out that hour. I mean, I don't care if it's someone's pregnant, mom died. I mean, holy moly, that's almost ridiculous. Sorry to say, but
yeah, but it's not the employer's job to stop other people from speculating about who the infected person is. It's the employer's job not to identify that person when they're going through this process. It's just it's the law.
Let me. So you're saying that, in the written word that we're not going to identify this person. What about the reverse of that? What happens when you have a dental assistant? Now we'll blame it on the hygienist. She's the go-to punching bag in dentistry, not the poor assistant, because the assistant's too close to the dentist. She could kick you under the patient. But a lot of offices, a patient says they had COVID a month ago or whatever. They were sick a month ago or whatever, and now her husband wants to come in, or a kid or whatever, and the staff says, no, we're not letting Mrs. Jones in. She told you on the phone her family had COVID. We don't. If we know they had COVID, we don't want them in here. How does your legal mind look at that?
Well, my legal mind looks at that and says, well, if you want, and if a sibling or a spouse or a relative of a patient of yours who is in the household where an infection is identified wants to come in, I think you say, well, okay, we need to see a negative test before you come in for services. All right. And this sort of has to, so that's my response. And it relates to the scenario. It's similar to the scenario where you have either a patient or a vendor come into your office and say, hey, I know, do you have a mask requirement? And you say, well, yeah, you have to wear a mask in the waiting area. You have to wear a mask until you get back into the chair. And then you take your mask off, but you have to wear a mask at all other times in the office. And so does everybody else in here. And the patient or the vendor says, well, I'm exempt because I have a medical condition that precludes me from wearing a mask. And believe it or not, there's even been, they've printed up these fake exemption cards that people are carrying around, which I just think is extraordinary. But anyway, if you have somebody come in and say that, what do you do? And the Department of Justice has made pretty clear that a person's belief that a medical condition that they have exempts them from a mask requirement is not blanket, does not create a blanket exemption for that person. If you want to say to the patient or if you want to say to the vendor, I'm sorry, and if you have a condition that makes it difficult for you to wear a face covering, we're sorry about that, but you can't enter our office unless you put it on. That is your prerogative. You should not experience any liability for standing firm on your mask requirement. That's pretty clear. I will just add to that if you have an employee, now, obviously not a hygienist or an assistant or a dentist, but let's say you have somebody in your back office that's doing your books or something, and they say, I have a bona fide disability that prevents me from wearing a mask. I need an accommodation under the ADA. Well, that employee, you need to go through the standard ADA analysis if you're covered, if you have 15 or more workers with that worker. You have to decide if there's a way to accommodate that worker's condition, if they truly have a disability that precludes them from wearing a face covering. You have a dialogue with them about whether or not you actually can somehow accommodate them. And if it's just not possible, then you don't have to. But just keep in mind, the analysis that will come into play with people who object to wearing masks is slightly different for a worker who may need to be accommodated under the ADA versus a third party who enters your practice space. The third party does not have the type of protection that the employee does under the ADA or anywhere else for avoiding a mask requirement. And masks, one of the things that is among many others that are keeping us safe. So we need, dental practices should have mask requirements, just like most of my medical clients, whether they be orthopedists, dentists, whatever, all these offices have mask requirements for workers, and patients and vendors.
Yeah, it really is interesting how people will get those cards.
Have you seen one?
I actually have, and I mean,
Yeah.
you can. It reminds me back when we were 16. When everybody was trying to get a fake ID to go into the disco places. They'd open up these disco places, but since they served 3.2 alcohol beer, you had to be 18 or have a card. And you literally went to Gary Gibson's house, and out in his garage, you had a photo deal, and he had a big old board, and it was a sophisticated, the things we did during the disco era. It wasn't my fault. It was the Bee Gees' fault.
I was going to say, because you've really dated yourself now talking about discos, but we can move on. I'm sorry.
I remember when they used to have some radio stations, their whole marketing campaign is, we promise we won't play the Bee Gees. Do you remember that?
Yeah.
They were so overplayed. My gosh, there's so many COVID deals. There's a lot of fear. There's a lot of paranoia. And I get it. You have your friends that are always saying, I can't believe they ruined the economy, for, 1,000 people dying a day. And I always say, well, it's fear. If anybody knows fear, it's dentists. People will come in with a bar through their tongue, paper clips to their eyebrows, and their whole arm is sleeved with a tattoo, and they're afraid of a shot. And I'm like, damn, you look like the last person on earth that would care about a shot.
Yeah.
But look at flying. I mean, one person died in a commercial airplane last year, and 36,000 died in a car. But if two jumbo jets were crashing into each other each day and 1,000 people fall into the ground, the whole country would have closed down every airport and every airplane in 1 second.
Right.
But when it's the economy and it's 1,000 people you don't need, but there's still just a lot of fear. I've had several conversations with people that says they don't care about catching COVID and dying. They just don't want to die slowly suffocating in a bed. The fear of that, they said, if I was ran over by a dump truck or whatever, they're fine with that. They just don't want to slowly suffocate being intubated. But so what happens when the dentist is thinking, my God, is my throat sore? And the assistant's like, I'm afraid I'm sick. And you're at work in the morning, you got all patients. Is one of those rapid antibody tests, or there's so many different things to test for. There's so many different ways to test. What do you do when your assistant says, I think I might need to be tested for COVID? I'm not feeling right, and maybe I have a sore throat.
I'd send him or her home immediately and then tell them to test. It's just, especially, I mean, you talk about like fear and everything with dentists, but with the collateral fluids, the spray, everything that goes on in a dentist's office, you folks literally have to be, maybe with the exception of the meat packing plants, which just were just like a proliferation of COVID, right up there at the top of one of the highest risk workplaces when it comes to COVID. And my thing is, I mean, maybe someone in a call center that is separated from all of his or her coworkers by cubicles with, 10 or 15 feet, says my throat's a little scratchy, I'm not feeling too well. Maybe the call center supervisor says, well, why don't you grit it out till lunch, see how you feel then, and then maybe we'll decide. But if someone if a staff member in a dentist's office, particularly one who interacts with patients, not a back or a front, not a back office person like an accounting or a bookkeeping person, is saying, I don't feel well, I think maybe I should get a test, I would have that person out the door in 60 seconds or less. Your workplace is just too high risk to second guess that self-assessment by a worker. Now, I will say, I mean, I just had a friend over Thanksgiving. It blew up their whole Thanksgiving plan because they were going to, go to a friend's house, and there were two families that were going to get together, and maybe it was for the best, but somebody in the group that was going to attend tested positive. And so my friend went to a rapid test center. I think they actually went over to the Phoenix College. And they show up to get a rapid test, which is advertised as, we'll have a result to you in 4 to 6 hours. And they show up, and the message they get is, we're out of rapid test. So we won't be able to get a test result to you probably for 4 to 6 days. So I guess in terms of staffing and, how you keep your office staffed in the middle of this pandemic, if you're going to try to get somebody tested quickly, I would be pretty deliberate about calling around to see if you really can find a testing site that has rapid tests available. Because we're testing a lot more, exponentially more than we did not just a month ago, but obviously 6 months ago. So I would just say, that's not really legal advice, it's just practical advice. You want to seek out the place to find a rapid test and hope that it's there when you get there.
Some dentists are asking, okay, so they're out for quarantine. They test positive. They can't work. How, for what would you say? I mean, some are saying 2 weeks, and now they're talking about they're shortening the quarantine period to 10 days. If a dentist tests positive to COVID-19, how long would the quarantine be right now?
Well, yeah, the CDC has backed off of 2 weeks. So it's more in the neighborhood of 10 days now. But I mean, all that is put to rest if the dentist in your hypothetical gets a test and then tests negative. I mean, you don't have to quarantine for 10 full days if you get a rapid test on day 5 and you're already negative. I mean, this is just practical advice, you just go back to work. Because I think what a lot of people don't realize is, especially given the high level of asymptomatic carriers of this virus, someone feels bad and then goes and gets a test and they test positive. They may have caught the virus 4 days or 5 days prior. And their symptoms, and I think this is why the CDC shortened the quarantine period, because the reality of it is everybody who gets COVID doesn't figure it out within the first 24 hours. You're going to have had that virus for a period of time prior to your symptoms starting, prior to your positive test result. So the answer to your question is get a test, get more than one if you have to. And once you test negative, then go back to work. And it's not going to be 14 days anymore. I just don't, I think that was a highly cautionary estimate at the beginning, which now we have been able to back off of because of our greater understanding of the virus itself.
So some dentists are asking on Dental Town. So they tested positive, but you know it's a strange virus because I was thinking of it two ways. Let's say there's Phoenix and Tucson. Let's say two cities of the same size that have 1,000 people, and in one city, 100 people. In one city, 10 people catch a virus, and one of them dies. And that would be, you could look at that and say, well, if there's 100 people, 10 got it, one died, it was a 10% fatality rate. But then the other city, everyone got it, but 10 got it severe and 90 didn't get it severe, but you still had one die. Now everybody says only 1% died from this virus. So the fact that 90% of the cases are mild to no symptoms, super spreaders, is really psychologically damaging. I just wish there were no mild cases and there were only severe, because then people would have a whole different relationship with it. But so dentists are, even though they're doctors and they understand biology and epidemiology, they're saying, okay, well, if I test positive and I got a quarantine from my office for 10 days, can I go in there after the office is closed and all my staff's gone to go do paperwork and charts and all that kind of stuff? Or would you say that's not a good idea?
I'd say it depends. And the reason I say that is because if that dentist is going to go in, walk straight down the hallway into his or her office and shut the door and do their paperwork, and when they leave, turn around, close the door, walk up the hallway and out the building, fine. And you let everybody there know, don't go into my office. I came in and did paperwork. I didn't touch anything else. I didn't go anywhere else. Keep my office door closed, period, end of story. But if someone like that is going to go into the office and make herself a cup of coffee and then, maybe pick up a newspaper out at the front desk, then that's ridiculous. No, you can't do that, because then you probably should bring a crew in and sanitize the whole place all over again, right? So I think it depends on how disciplined that person is if they want to go in and do that. They need to keep themselves in a defined area and let everybody else know what that is so they don't enter it.
Okay, this is a tough question for you. It looks like we're really, really close to having these two vaccines being released. I mean, Moderna, these two new messenger RNA. I remember, I was always saying I would never bet on this vaccine because everybody's been trying to vaccinate the common cold since I got my first vaccine. I remember in dental school when I got my first vaccine, they said, now remember, this is influenza. This isn't the common cold. And the common cold is 90% rhinoviruses and 10% coronavirus. And I said, well, why don't they vaccine for that too? And they said, oh, they will. That'll probably be next year. Well, that was in the 80s.
Yeah.
So when and then they told me in dental school that I had made a horrible mistake because they were this close to vaccinating Streptococcus mutans that causes decay and P. gingivalis that causes gum disease. And they go, dude, you should have stayed cooking hamburgers with your dad at Sonic Drive-In, because this is your whole career is going to be vaccinated away. So when they said they were coming out of vaccine, I just thought, no way. I mean, I've been watching this for 40 years. I watched YouTube videos of virologists that had been working on the coronavirus vaccine for the same time that I've been a dentist. I mean, they graduated in the 80s, their whole career, and they go, no. not going to. They were glad they're going to throw a bunch of money. And then I got reschooled halfway through this thing. Like I say, I can't believe that when I had you on was about this with Gordon Christian, that was, oh my gosh, 249 days ago. We should have podcast you tomorrow, so it'd just be a 250 days. I mean, it just seems like an eternity ago. But halfway through it, then I got reschooled by people talking about, well, if it only had a 50% efficacy rate. I mean, so a couple vaccines would be great. We'll get this herd immunity. And I think everybody was blown away when they came out with this messenger RNA, which, we spent our whole life with attenuated vaccines. And this is the first messenger RNA vaccine. And even Fauci was blown away when he said, my God, it's 95% effective. Nobody saw this coming. But it's a new vaccine. It's not the old attenuated vaccine where, they bunch of chopped up dead polio particles for a polio vaccine. This is a whole new deal. You're a really smart guy. They're going to start releasing this December 21st. Are you going to take the vaccine?
Oh yeah, I absolutely will. I mean, I know I've been reading with a lot of interest because I'm not a medical professional, obviously, but the concept of the type of vaccine we're talking about, where you're actually almost embedding biological software into your body to take care of the problem, as compared to the old traditional or conventional vaccines, is fascinating to me. And to me, that doesn't scare me. What that means to me is that is a reflection of this efficacy rate. I mean, that's a brand new vaccine with a 95% rate. Well, something's got to be different about it. And we really this is what we needed. It doesn't scare me, but the reality of it is, Howard, it's going to be a while after December 21 before I get it. I mean, the panel met today to decide the order in which it's going to be given out. And I'm not anywhere near at the top of that order. I mean, it's going to be, and I'm not complaining. I'm just saying, so as a practical matter, I'm probably going to be able to sit back and watch for a month or two of experience to see how it actually plays out before I ever even have access to it. But no, absolutely. I think we all should do our part and get it. I mean, it's the way we're going to put this thing to rest as quickly as possible.
Why do you think married men are so much more eager to try out this new vaccine than single men?
There's probably half a dozen answers to that question.
Well, do you think when they try to prioritize it, do you think it's going to be, like on the Titanic, women and children first, or do you think healthcare providers? I mean, I would think if you're working in a damn hospital or in healthcare, you'd want to be high at the list, but probably the highest on the list should be the elderly. I personally think that short, fat, bald dentists should be first because they're old. They're healthcare providers. Don't you think old, bald dentists should be? And plus, you don't have to worry about side effects like hair loss or anything like that. But
right, and then if you wear glasses, then I think you even get further up to the front of the line. But no, I mean, I guess they met today. They're probably talking about what they decided while we're sitting here talking on the podcast. But I would think frontline workers clearly, then people who, and not just elderly, but people with pre-existing conditions that make them more susceptible. And then you're just going to sort of go down the line from there based on the science. We've seen that, more children, more younger people have contracted it as it's progressed than what we saw at the beginning. But I still think that there are groups of people that are easily identifiable that are either at higher risk or at greater need to have it that should get it first.
But do you think dentists will be? Do you think dentists? I mean, they're not at the hospital, but do you think dentists, being healthcare providers, from what you're hearing, do you think it'll be near the top of the list of?
I would think so, because you're, although you're not a frontline worker in the sense that you're not there dedicated to treating people who we know have it. It just goes back to what I said earlier about what the risk factor in your workplace is given what you do. It seems to me that dentists, any sort of professional in your area, orthodontist, dentist, oral surgeon, those people should be somewhere near the top of the list just because of the services you provide that are needed and the level of potential exposure and risk that you encounter because of what you do.
Yeah. How many years have you been a labor attorney? I mean, you've been with me for decades. How long have you been doing this?
Like 33 years, I think.
Has COVID taken over your practice? I mean, is most of the people calling you about COVID, or are you still doing a wide range of other labor laws? So is this kind of taken over, or?
I think for the first 3 or 4 months, it really hijacked the whole thing. And for a couple of, so you're talking April, May, June, July, and there were, I think, a couple of reasons for that, which is just a reflection of what happened. There was not only the complete and utter uncertainty and lack of knowledge about how to handle any number of scenarios, but there was the quick turnover of laws being passed. There was laws. There were multiple stimulus bills that had embedded in them different aspects that dealt with the virus, both in the workplace and financially for employers. And then you had the fact that people were starting to contract it, and employers didn't know how to handle those situations. And so for a period of time, we really were preoccupied with learning the law and figuring out how to advise people about it. And now it's sort of settled down because I think a lot of employers have become really well educated about it. I think when we get to the end of the year and some of these laws that are due to expire at the end of December come up, we may have sort of a second wave of inquiry, because it's kind of like, well, okay, we talked about the FFCRA earlier in the podcast. If that expires at the end of December, then do employers have any obligation to give people time off if they contracted, or they're quarantined, or they have kids who can't go to daycare? What's the status of all that? So it's been a pretty busy COVID-related year, but we've had all the other stuff that we typically do there to do. So we've just been busy generally.
So the vaccine comes out. They're saying December 21st. I'm reading that they might be able to do 20 to 30 million Americans a month. I mean, it's a fast moving target. But let's say that it's out today in Phoenix, Arizona, and it's available, and your staff, again, we'll just beat up the hygienist. She seems to be the go-to person in dentistry. Your hygienist says, I'm not taking the vaccine. As a labor attorney, how does that affect the dentist owner? Is he fine with that, or is that a legal problem?
Well, I think the question that begs for me is, what is it that's driving that worker to resist getting vaccinated? If the worker says, I have a bona fide disability that prevents me from getting that vaccination, or that puts me at high risk for something else if I take it, then once again, if you have 15 or more workers, you're right back smack dab in the middle of the ADA analysis again. So the person has a disability. Is there some way for you to accommodate it? You'd have to go through that. You'd have to engage in the dialogue with that person about those things and see if there's some way to accommodate the person who says that they can't be vaccinated. Now, if this is just a person and maybe you have a person who says, I can't be vaccinated because of my religious beliefs. Once again, you would need to go through an analysis relating to that under Title VII. I'm not saying that when at the end of the day, at the end of those analyses, all those people are going to get a no vaccination, get out of jail free card. I'm saying that you need to go through that process and determine whether or not you can accept that resistance and continue to have to employ that person. Barring a protected characteristic that would prevent the person from getting vaccinated, if you just have some worker who says, nah, I'm just not inclined to get it, and I hope you're okay with that because I'm just going to continue to come to work. I think in an at-will employment state, unless that person has an employment contract, you would be free to say, I'm sorry, we are, absent special circumstances, we are requiring all of our staff to get vaccinated. And if you're unwilling to do that, we're not going to be able to keep you employed here. So I think it depends on a number of factors that you would have to consider and look at, and each scenario would be obviously different.
And, I always like historical perspective, because when you get older, you look back. But I remember I took the hepatitis vaccine when it just came out, before it was even available for the public. You know what I mean? And the insurance companies didn't pay for it. I even paid for my 4 babies to be vaccinated against hepatitis B. I think it was like $150, and them were $19.80 and $19.90. So I was very aggressive with the hepatitis vaccine, because I was so afraid that I was going to bring home hepatitis on me, because you walk through that door and they jump you, and you just couldn't say, well, wait till daddy takes off all his clothes, showers. It's too late. And they're little kids, and you're like, God, I hope there's no blood on my, sweats or uniform or whatever. I think, it's going to be interesting to see how many people take that vaccine right out of the gate. So if it's I want to know what I want to ask you is, so again, the cutoffs are, when does small start getting large? I know there's some laws that don't kick in for a general dentist who owns his own dental office till he has 15 employees. I remember Lori schooling me one time where we weren't going to hire another person, because if we hired one more person, we crossed the 50 line.
Right.
And she did not want to cross the 50 line for a whole bunch of reasons. So we started doing things where these were contract workers or things like that. But what are the benchmarks? If you're a dentist working for a big DSO that's got scales of management, they have their own people advise this. But if you just own your own dental office and you're a small town owner operator, how many employees do you start having different rules for? You keep mentioning 15. I know 50 is another one from somewhere that you've coached me on. But what are the numbers that make you enter a new territory?
Well, the significant benchmarks are really 15, 20, and 50, 50, the ones that you've been identifying. So 15 or more employees triggers coverage under the mainstream employment-related anti-discrimination laws, like Title VII, which includes gender, national origin, race, all those core categories. When you get to, and 15 also covers disability. So if you have 15 or more, you're covered by the ADA, the Americans with Disabilities Act. When it comes to age, it bumps up to 20. So if you have 20 or more workers, then you're covered by the Federal Age Discrimination and Employment Act, which then requires you not to discriminate against people who are 40 years old or older. When you get to 50, then you're covered by the Family Medical Leave Act, the federal law that provides up to 12 weeks of unpaid leave for employees who have a serious health condition. Now, one caveat to that is that under the FFCRA, the law that got passed earlier this year dealing specifically with the pandemic, that law expanded the FMLA leave right, and that now includes paid time off if the leave is COVID related. Normally, under the traditional FMLA, an employer with 50 or more workers would have to give unpaid time off to a worker with any serious health condition that satisfied the definition of the law. Now, if it's a COVID related condition, that time off is 10 weeks of the 12 weeks is paid, as long as it fits into the criteria in the FFCRA for COVID. So the FFCRA essentially expanded the FMLA for 2020. That expansion, that paid time off that the FFCRA created under the Family and Medical Leave Act will expire at the end of December.
On Dentaltown, under law and ethics, we have ethical issues, legal issues, licensing by credentials. We should really add labor law there.
Sure.
I mean, it's just a huge thing. I can't believe we've gone over an hour, and I could talk to you for 40 days and 40 nights, and willing to stay with you till midnight. But what was your majority of your practice 250 days ago before this hit? When you had a dentist on the phone, what were the main issues pre-COVID?
Well, my practice group at Jennings is a full service, 15 to 20 lawyer deep department. And we handle just all aspects of mainstream employment and traditional labor law. So whether you're unionized or not, whether you are litigating or you just need counseling, writing, training, investigations, or whatnot, we just do everything. There isn't anything in the employment area that we don't handle for businesses. And so I guess there probably isn't one single thing that occupies our practice more than anything else, because we are multidisciplinary practitioners, meaning we can go to trial, like we talked about at the beginning of the podcast, or we can write and counsel and train. We try to prevent problems from happening before they result in a lawsuit that may or may not go to trial. So best answer to that question, Howard, is everything employment related that you can think of, we do day over day and we can handle.
Is that a, dentists have malpractice in case a patient sues them. They have commercial insurance in case, someone slips and falls on your property. Is there labor law insurance?
Yeah, and in fact, that's a great question for those practitioners out there who are listening that either, and a lot of employers don't even know that they have it, because this type of insurance that you're talking about often can be embedded in a general policy, like a CGL policy or property or general liability policy, either as an endorsement or a rider, and the employer may not even know they have it. It's called Employment Practices Liability Insurance, EPLI. And it functions the same way really as like a car insurance policy does. You pay a premium depending on your experience, the size of your workplace, what type of business you're in, and how much you want to spend, what sort of deductible you want to have. Your premium may be higher or lower. And then if you experience a claim, which is fairly broadly defined in these policies, that will trigger coverage. And in most of these policies, the carrier then has to both provide you with the defense as well as indemnify you. And the only skin in the game that you have as the business is your deductible, which could be $5,000, $10,000, $20,000, $50,000, depending on what sort of premium you want to pay when you bind the coverage. If you look and you don't have that coverage, I would highly recommend you exploring it. 10, 15 years ago, it was an anomaly. The carriers sort of put their toe in the water to see if they could make money off of it. And I think it's been very good for them, but it's also been very good for businesses. One carrier that I think does a fantastic job is Nationwide. I've worked for Nationwide insureds for 20 years. I handle a lot of claims for their insureds. And all of their claims professionals are attorneys in their EPLI unit. They do a great job, but a lot of carriers write the coverage. Chubb, Travelers, Philadelphia. But it is something I would highly recommend those of you who don't have it exploring, because when you do get that claim that you think you're never going to get, it limits your exposure, and it prevents you from that catastrophic $100,000, $200,000 trial that you don't want to have to finance if you can't settle your case.
Back to labor laws. A lot of people, it just seems intuitive that people are afraid of the dentist. I noticed raising 4 boys that, daddy's great until they fall down and get a boo-boo and start crying. They would literally run around me to get to mom. I mean, there's just women just seem softer, gentler, more, pediatric dentist. To me, it seems obvious that women pediatric dentists out of the gate next to a man across the street, they just grow faster. I've seen research that moms who make 85% of all appointments, they just ask would rather ask a woman a question than a man. I've seen research that says that they trust women more, and they should, because it was the University of Chicago, who, by the way, that is the university for economics in America. Go to that place. I remember walking down a hall, and every one of those big pictures was someone who got a Nobel Prize from Chicago. I mean, it is just the house of economics, and they were publishing research with undercover economist women with economist men, and they would be quoted different prices on cars, and guess who was quoted the higher price?
Oh, for sure,
The women. So now you have dentists who want an associate, who are advertising, I want a female associate dentist, and I'm like, whoa. I mean, is that even legal? I mean, or is that, you're basically saying, I want a woman, not a man. Could a man dentist looking for a job say, I've been discriminated against in the workforce because they specifically are asking for a female?
Yeah. The answer is yes. And there's a couple of things to keep in mind in connection with that yes answer. One is, again, keep in mind that unless you have 15 or more workers, the anti-discrimination law that protects workers against discrimination based on, for example, gender, does not apply to you. So if you have a practice that has 13 employees and you want to advertise and say, I'm only going to hire a female dentist, maybe for the reasons you've described, you're welcome to do that, because you're not covered by Title VII. And in Arizona, you're not covered by the Arizona Civil Rights Act, both of which require 15 or more workers to cover you. The next concept, though, that is important is, let's say you are covered. Let's say you've got 20 employees and you want just to hire a female practitioner for the reasons you've described. There's a concept in the law called BFOQ that stands for Bona Fide Occupational Qualification. And some industries are able to impose those sorts, or use those sorts of arguments in order to avoid is the wrong word, but in order to enable them to do what you're describing. For example, an airline can say, we're not going to hire an individual as a pilot that has an ocular disability. Well, having certain type of vision is a BFOQ for a pilot in the airline industry. That Delta or American, whatever carrier, would say, we're not hiring visually impaired people, can do that, even though another employer that doesn't have that restriction or need could not. Now, in your case, you're saying, well, we want to sort of develop our pediatric practice, and we think that if we just hired a woman, we may be able to enhance that practice a bit, because the kids are just going to sort of want to gravitate toward that dentist more than the men. I don't think that's a BFOQ. So if you had 15 or more employees and you got on Indeed and posted that job and said only females can apply, I think you'd probably create a problem for yourself. So depends on the circumstances, depends on your size, depends on whether or not you have a BFOQ argument to make. But by and large, that's probably something you'd want to check in with counsel on before you posted a job ad like that.
Yeah, and another thing that I wish I would have known more of when I was little, but my mom always said, when you ask about a judgment thing, whenever you'd ask your mom, what would your mom say? Well, Howie, if you have to ask, you already know the question. So that's something where I didn't really take heed of that for about 60 years. And considering I'm only 58, that's hasn't even kicked in yet. But if someone, if I met you at a party and someone said, you're a labor attorney, my walnut brain would think that you basically do 4 things: workplace injuries, sexual harassment, discrimination, wrongful termination. So is that kind of true? And is this COVID thing really a workplace injury? Is that the 4 main? Like if I told you I was a dentist, you'd think a root canal filling and a crown and a cleaning. I mean, is that basically some of labor law for dentists? Workplace injury, sexual harassment, discrimination, wrongful termination, and and this whole COVID issue is just another workplace injury issue, or is that overly simplistic?
There are some other laws that can often come into play in any size workplace, and then there's this whole separate collateral area that doesn't even deal with any of those sort of issues that arise, and that is employee benefits, compensation plan structures, professional contracts. Most of your practices, when they bring on a practitioner, either as an employed physician or as a shareholder or a partner, they're going to have some sort of compensation or executive plan contract. The National Labor Relations Act, which deals with workers, coming together as groups to complain about working conditions, that has its whole separate structure of dispute resolution that has nothing to do with the type of claims that you were describing. So although I think what you've described for a dental practice would kind of be at the core, there still are a number of things that I can think of that we would do and do for dental practices and other medical professional practices that are outside of that core, but that still come up an awful lot. And training, like I say, writing, employee handbooks, policies, investigations, all sorts of things that still can arise, but maybe not as frequently as the type of the issues and situations that you described.
I want to ask you a question totally unrelated, but I'm going to ask it's kind of true. When you buy and sell a dental office, the seller gets an attorney to sell and the buyer gets an attorney to sell. And way back in the day, the number one leader of this was Alan F. Thornburg in Atlanta, Georgia, where he started this dual representation. And he was like, he correctly said, you can't get two dentists to agree on anything, and I'm not going to have two lawyers go to war and make a mountain out of a molehill. So I'm going to analyze the practice, the value, and I'm going to represent the buyer and the seller. And it was dual representation. And all the attorneys on Dental Town would say, well, if he's representing the seller, who's representing you? And he'd say, well, I'm representing both of you. And all the lawyers would say, no, that's impossible. But lawyers have been using mediation a lot more. Like if you go to small claims court, a lot of the small claims court says, well, first we're going to put you in a room with this mediator and you guys just try to solve it. And if you can't solve it, then we're going to do it. And some now, a lot of contracts, they say, if this goes south, you're agreeing that you'll do mediation first. So do you see mediation, arbitration, and dual representation on buying and selling a dental office the same thing, and it's not a red flag? Or is that a red flag to you?
Well, it's not the same thing, because I have a mediation and an arbitration practice too. And when I'm engaged as an arbitrator or a mediator, the parties are jointly hiring me either to try to help them resolve their dispute or to decide it. I'm not representing either one of them. It's not dual representation. I'm being engaged as a unbiased, neutral third party to provide a service. Neither one of them is my client. Now, in terms of dual representation on actual matters, like what you're talking about, a business transaction, as far as I know, the only really surviving the main surviving dual representation model exists in real estate when you're talking about real estate agents. You still have the situation where you can have one real estate professional representing a buyer and a seller. I think it's awkward, but I still think it's permitted. In the legal area, that is an absolute positive recipe for disaster. And I don't even think ethically we can do that anymore. I mean, we can't, I don't care if two people come to us and say, we want to just hire you to be the one lawyer who represents both of us in our dissolution or in our business transaction. The answer is no, we can't. We just can't do it. Can't do it because we are building in an inherent conflict into that engagement. It may never head south. It may never blow up on us. But if it does, we're going to get disciplined for doing it. But that's completely different than working as a mediator and an arbitrator. There's no.
So you're saying in real estate, there's really not dual representation?
I think it still exists.
Oh, so you're saying it does exist in real estate?
I said I think that's the one area where it has survived.
But you don't see it. You don't see it as a great idea in buying and selling a dental office. The old man.
No. I would never get involved, and I don't think I doubt that any lawyer. We have a whole. Keep in mind, my firm is a multi-practice, full-service law firm with 70 lawyers and multiple offices, and we do everything. I mean, my practice that I manage is a niche within that firm. We've got a whole group of people, securities lawyers, M&A guys, deal people, buy and sell businesses all day long. I don't think any one of them would touch a situation, even if they had two parties coming to them and begging them, represent both of us in this business transaction. I don't think we would take, I think we'd say, we either represent one of you or none of you. It's just, you can't do it.
So it's one of those things where you're saying it's only really surviving in real estate.
That's the last area I remember, because the first house I bought, I drove by a house and I saw a sign. This was like in 1988, and liked the house, but I hadn't even hired a realtor. So I called the number on the sign. I even remember the guy's name, and he ended up representing me and the seller. It was dual representation, and the printed form American Association of Realtors contract that we signed had a dual representation clause in it. It was above board. It was permitted. It's not my area of practice. I don't think that's changed, but lawyers don't do that.
So it's still a niche going on in dental practice, buying and selling. I mean, there's still one of the biggest national chains, AFCO, does that. Paragon Practice Transitions does that, but but you wouldn't recommend that.
No, I wouldn't. And maybe in those situations that you're describing, maybe in the background, maybe those parties do have separate counsel that are there in the background, still representing their individual interests. But as a pure transactional proposition, if a buyer and a seller that wanted to engage in a business transaction came to us and said, represent both of us, I think we would immediately say no.
Like say, we talked about how fear is weird. Like, I know at least a dozen patients that won't fly. Remember John Madden, the big football announcer?
The big, huge motorhome.
And you're like, now there's a classic example. There's a guy that could get ran over by 6 NFL players that I would never, I know I'd die. He wasn't afraid of getting tackled by 6, by all that, but he wouldn't get an airplane. So fear is just bizarre. And I've seen the same thing on dentists. Like, they'll get a bad review. So someone will write them a bad review on Google or Yelp or whatever, and they just have a meltdown. And I'm like, man, you got to age 50 and you didn't know that there was one guy on earth that didn't like you? I mean, how do you get that far? And another one that just irrationally makes them go insane is when someone tries to file unemployment insurance, make a claim. And their first instinct is, I'm taking this to the Supreme Court. This is not going to happen, Is your advice, just relax? It's a system. It is what it is. You don't want to, you're not going to go move to another country over it. Or is there a lot of fraud in there, and it's worth a call to a labor attorney when someone's trying to make an unemployment claim on you?
Well, a couple answers to that question. First, the eligibility, there's 2 steps to unemployment claims. Are you eligible? And then if you're eligible, are you qualified to receive the benefits? Keep in mind, employees who quit are not eligible. They're not eligible, so they can't even file a claim. If the employee is fired, then he or she is eligible. And then you have to decide if they are qualified to receive the benefit. And our Economic Security Act in Arizona defines very precisely what things qualify them or disqualify them from receiving that benefit. Insubordination, stealing, tardiness, all those things will disqualify the worker. But general stupidity, general poor performance, that worker you fire who just isn't doing a good job is going to get benefits all day long. So you can look at the situation and contact counsel for 5 minutes and decide, is this even worth fighting? Because depending on what the person did to get themselves fired, there may be no point in contesting it. It may be a complete waste of time, okay? The other thing that comes into play is very often the person who files the unemployment claim is also a potential subsequent litigant. You may end up in a dispute with that person in addition to the unemployment claim. And what we tell employers all day long is, if you get into the unemployment system arguing with this worker about that claim, you risk getting in front of an ALJ, an administrative law judge, and getting tape recorded under oath to support your challenge to that claim. That transcript of that testimony can come back to haunt you in a subsequent lawsuit all day long. You're not prepared for it. You don't have no idea what the person's going to sue you for. And you may say things in that minor, insignificant unemployment compensation proceeding that you don't want coming back to haunt you in a subsequent, significant, consequential lawsuit. So we say to employers when they ask this question, okay, well, what are the circumstances? Why did you fire him? Are they a potential litigant? And so on. All those things would come into play in deciding whether to contest it. Keep in mind, unemployment insurance works just like a car insurance policy. You know, the rate you pay, your UI tax rate, that premium, if you will, fluctuates only slightly depending on your experience rating. 1 or 2 additional claims that get paid out is not going to make that much difference to you in the end in terms of your pocketbook. So I think you need to look at unemployment claims very carefully. And a lot of times it is helpful for 5 or 10 minutes of lawyer time to just go through that analysis, because usually after 5 or 10 minutes, the client will say, oh, clearly, I mean, not even going to touch this or whatever. It's very easy. So complicated answer, but there are a lot of moving parts to it.
Is the old, is the sexual harassment actually the most money? I'll never forget when that dentist, dentist sexually harassed assistant, $1.7 million bench verdict, San Bernardino County. That was on in 2013. Oh, the date of the judgment was 2016. It was filed on 2013, but man, it's only 2020. That was only 4 years ago. Was that the biggest thing you've ever heard in dentistry? That one was that? Is that category?
That verdict? Yeah. Oh, Howard, I'm sure there's been much larger ones than that. I mean, for a bad sexual harassment case, that's not a particularly large verdict. I mean, if the facts are really bad, juries hate. Well, that was a bench trial, so apparently
what does that
judge
mean?
Got really. Pardon?
What does bench trial mean?
That means the judge decided that without a jury. So someone really got a judge exercised about what went on in that case. But juries don't like. I mean, bad sexual harassment claims are things you don't really want to end up in front of a jury on. That's another reason why a lot of those, not just because they're so expensive to litigate, they're very risky to go to trial.
Because it's just something that jurors don't like.
They don't like. Yeah.
Yeah. But I always thought that sex is a lot easier to understand than if it's, embezzlement or, all these other types of crimes. But sex is a pretty easy one to stand out. But is that category of sexual harassment, is that usually the most money? When you're a labor attorney for dentists, is that usually the highest ticket item?
No. I mean, I think they are one of the more risky claims to defend, but they're not necessarily the highest ticket claims, because you could, if you're, as we've been talking, if you're covered by one of those laws, whether it's Title VII or the ADA or the ADEA, and you fire somebody because of a protected characteristic. And you get into this particularly when it comes to age, because the older workforce is more challenged in terms of reemploying themselves than a younger worker. And we see high risk in age discrimination cases. Juries don't like them either. There is a certain emotional, very subjective emotional element to sexual harassment cases that make them particularly risky. But frankly, any case that has bad facts involving unlawful discrimination can result in a significant verdict. It's just a fact.
And let me flip that around on the cases where there's several of them where the dentist didn't do anything wrong, but his actual dental assistant got caught sexually assaulting patients who were under anesthesia when the dentist was not in the room. They're in the recovery room with them, but the dentist would be just as liable for that, right?
Well, I think it depends on how the practice is structured. An employer can be vicariously liability for the bad acts of its workers. And so if that was a situation where that practice was not a corporate entity, not a corporation or an LLC or a partnership, and that dentist employed that assistant directly, yeah, that individual dentist could be vicariously liable for that misconduct. If it's a corporate structure, maybe not. That vicarious liability, that individual dentist who might own that practice, maybe the sole shareholder, sole member of the LLC, is going to enjoy a certain amount of protection because of that corporate structure against that vicariously liability when it comes to his or her personal assets. I think what's going to come into play in a scenario like that is, how is that practice structured? Does that individual dentist employ the assistant directly? Does that individual dentist have a corporate entity that employs the assistant? You'd want to explore those questions in order to decide if that liability would attach.
Man, I could listen to you forever, but what I'm just trying to tell you guys over and over and over, I know you're wicked smart. You couldn't have got into dental school, medical school, law school, unless you just had a long history of knocking out A's. And I think it actually works against you, because I think most people, the minute a question comes up, they think, well, I need to talk to an attorney. Where dentists and physicians, the first thing they think is, well, I think I understand this. And gosh, think about everything he's saying about labor law. After you've done your first root canal, or your 1,000th root canal, or your 10,000th root canal. The devil's in the details. And again, everybody who's out there crushing it and successful, they have developed a really neat team. And Ray Harris was the first one that I needed a really good attorney with starting Dentaltown, of all things. It was crazy back then. You got to remember, we started that in 1999. And it was a new thing, and it was a very bizarre deal. And I actually called every internet business I could, asking, do you know any attorneys who know anything about this? Because back then in 1999, most attorneys I talked to, they didn't even have AOL. Or they're like, are you talking about that AOL dial-up? Yeah, I keep getting that free CD, that free CD-ROM. I've never installed it, but is that what you're talking about? And I'm like, God, I need someone who knows the difference between AOL.com and a damn website. And I'm really proud of myself looking back, because I just I kept looking for every internet type business and calling them up. And the first guy who had a deal, this I did. The first guy had a deal, and I said, okay, that's one. But then I went to my my patient list. I was on a computer, and I plugged in attorney, and I pulled up every single attorney that was in my office, and I called every one. And there were 3 or 4 or 5 attorneys got 1 vote, and then this Ray guy got like 7. And I thought, okay, and that is how. And I learned that from the founder of Intel, Andy Grove. In his book, what was it? Only the Paranoid Survive. And they said, Andy, okay, I know you got a PhD, but there's a lot of people with a PhD, and you always seem to pick the technology that's going to win in the end for all these how do you always pick the winner? And he goes, well, it's very exact. He goes, what we do is on all these new technologies, we track their sales and their units sold every single month. And it's like a horse race, right? And then all of a sudden, one pulls out in one quarter 10x.
That's one.
And that what was that horse back in the day that won the Triple Derby?
Oh, yeah, I know what you're talking about.
Yeah, and when someone breaks out 10x, it's always been the winner. And last question. You've been so nice. You're over time. So now a lot of dentists have decided they're not going to be owner operators, and they're going to be employees for these big DSOs. And the first thing I thought is every dentist I know who got a divorce and went through a breakup with his partnership said the partnership was 10 times worse than the divorce. Because the divorce, you have all these glues. You got family and kids and all this, and people don't want to go to war. But I started thinking to myself, oh, my God, could you imagine being a DSO with 100 dentists as employees? I bet their labor law issues will just be insane. Do you think these DSOs are going to be challenged by the fact that now they got employees who are dentists? They got 8, 9, 10, 12 years of college. They're very anal. Do you think they're going to be far more challenging than what dentists have usually had to deal with assistants, receptionists, and hygienists?
No, because I have clients, medical professional clients that are massive like that, with 200 providers and 800 support staff. And I have not found, even on that scale, you would almost expect, okay, well, with an organization that big, you're going to see more claims, just generally speaking, because it's like 20 times bigger than your average practice. I don't see it.
So
I don't know what explains it. They all seem to get along. I think one of the reasons is because when you get to that scale, when you get to that magnitude, I think just naturally as you grow that large, the sophistication of your operation and your infrastructure at the HR level, at all levels, just is up a notch. And I think because of that sophistication, you avoid problems. So no, I don't think, a lot of, you could name them. There's so many different medical industry groups that have got, anesthesiology, renal, orthopedics, that have gone to these large consortiums of providers. With a lot of support staff. And that's different than going to a hospital and working as an employed physician. I'm talking about a massive private practice that has employed providers and equity providers. And they seem to do very well.
And that is, I don't like the term DSO because it's already, humans start attaching humans always do that. They attach a very strong emotion to a word, like if you just say climate change, they're either this way or that way, it's a strong word. But I always see DSOs as just group practice. And when I opened up my office, I hired an associate just because, hell, I went from 120 dentists in my class at dental school to being all by myself. I just wanted a buddy. And I was so damn dumb, I hired someone just as young and dumb as me. Looking back, I should have hired, a 65-year-old guy. But yeah, when you get to 3 people or maybe 3 locations, you can afford to have a layer of like my Lori, the president that's not answering the phone. Like everybody tells me they're an office manager. I just stand there and look at them. They're checking in patients, checking out patients. They're doing a financial treatment. I'm like, well, you can put on her title office manager, but she's not an office manager. She's a front desk at a dental office. And I've noticed that whenever you get to a certain level where you can just afford one layer of management in like HR, accounting, then that's how you really just answer that in my mind, that they got big enough to get a layer of professionals So it's actually not an issue.
That's what I'm talking about. Yeah.
Yeah. And what I fear is that one solo practicing dentist, he's all by himself. He has to wear every hat. He has to be HR, accounting. He's got to know his numbers. He's got to understand advertising, marketing. He just has so many hats to wear. And I think this COVID-19 obviously was the last straw for a lot of them, because everybody's selling practices. They can't even take all the phone calls. My DSO friends said they got a laundry list a mile long of dentists that want you to come save me. So I think this pandemic was a huge brand builder for group practice. I don't want to say DSOs, because that's going to trigger a bunch of negative emotions, but I just think that dentistry is getting so complicated. It's really hard to do it alone. And I am so lucky, because what I did is I just was obsessed with trying to find a management team of like Lori and Stacy, who have been here for decades and decades. And when all this stuff, like when a labor law issue breaks out, I don't even have to worry about it, because I know they're calling you and they're hands on deck. And it's nice to have a scale. And what I think is the most indefensible is, like, when you go into a town, Facebook and Google. Facebook's like 98% of their revenue is from advertising. Google's well over 85% or whatever. And so they've killed radio and print and TV. And a lot of these guys are in towns of like 250,000. They're on the north side, and advertising on Google and Facebook's really expensive. Whereas in Phoenix, where we are both right now, there's radio stations you can buy if you just take over the lease of where the station is. I mean, Clear Choice, they can buy 30-minute television infomercials and radio deals for almost nothing. And so they'll say, you know what we're going to do? We're in a town at 250. We could put a billboard by the highway. We could have radio. We could have TV. We could market for we could get 5 times as many patients for 1/5 the cost if we scaled. That first scale level is indefensible. I mean, you just can't compete against a group of 4 practices, north, south, east, west. Where I'm not sold or convinced is the second layer of management, where you say, okay, you guys have this in Arizona, but we're going to sell to a company who's in another state, and they're going to take another 15, 16, 17% off the top. It's like, wow, you got to be really, I don't even pay that much for my labor and supplies combined. How are you going to be so efficient for me that I can give you the cost of lab and supplies off the top? But that first layer of management, like the luckiest thing I did, I was a dentist, and I decided I wanted to start my own magazine. Just like my podcast called Dentistry Uncensored, they wouldn't publish my stuff. They would edit it down so clean, I didn't even know I wrote it. It's like, and all jokes are gone. It just wasn't me. So I had to start my own magazine just to get published. And because I was published 4 times in the American Dental Association. And again, by the time it got through the editors, they took a 6-page masterpiece and condensed it to 120 words of duh. I wanted to write about things that I don't want to talk about anything everyone already knows. I want to talk about the nitty gritty of these details. And I'll tell you what, I love the DSO first level scale. I mean, my God, to be able to get in someone who only does marketing, who only does HR and labor law, who only does accounting and knows the numbers, where they can tell you, yeah, we signed up for this plan and it does pay $150 on a filling, but in our office we net 14% after taxes on that filling, and that's a go, especially in an S&P 500, where the average stock only has a 5% profit margin. So I could not do that without Stacy and Lori and Dawn and Ken and all that stuff like that. So all I'm trying to tell you guys is that, my gosh, if you're going to wear a lot of hats, you need a great team. And my final question to you is, I know you need your own bookkeeper in your office. I know you need a CPA to help file the tax on that. But when I tell them they need a great attorney, how many attorneys would that be? Because labor laws, especially for the average Joe dentist, Harry, Jane, dental office, how many different lawyers would need to be on their team?
I think the way it should work, Howard, is what I do with all of my clients. I mean, I'm the point person for the client. Like I'm the relationship lawyer for that client. And every problem they have, it doesn't matter what area it's in, they call and present it to me. And I know enough about some areas to be more than just dangerous. And some of the things that it may be slightly outside of my area, but I can solve them. I can handle them. But if it gets deeper than that, then because of the fact that the firm has a deep bench in all areas, I can then go to somebody and say, solve this problem or solve that problem. And so there may be, depending on what the nature of the issue is, a handful of lawyers in the background waiting at any given time, but I try to deal personally with the client myself as much as possible. And it's not like they're dealing with a dozen lawyers. So, and that's really the way, I mean, that's the way it should be. I think clients shouldn't necessarily hire law firms, they should hire lawyers. But if you're at a deep law firm where you have resources, you can solve all your clients' problems and remove the complexity of it for them. So.
Yeah, I agree. And you and Ray have been wonderful in those areas where Lori or Stacey will call you and say, "Will you look at that?" And you'll say, "No, you really need to talk to Susie Q because she only does this type of law." Just like dentistry. When I got out of school, there were 9 specialties in dentistry. Now there's 12 specialties.
Right.
And when these other specialties pop up, dentists are really, really great because they're like, man, that is a really complicated, like oral medicine. I mean, I really don't want to review a health history 1.5 miles long, and this is all you do. So if you get one really great attorney, what you're saying, that's really worked well and you trust, they're going to be able to refer you to someone else who's a specialist.
If necessary, yeah.
If necessary. Well, man, thank you for all that you've done for me. And again, there would not be a Dental Town if it wasn't for Ray Harris. Because in 1999, when I got when that whole deal was going on, I mean, that was the wildest thing that ever happened to me. And I thought it was over. And Ray just laughed and he said, no, that's not going to happen. And so it wouldn't have been Dental Town without Ray. I wouldn't have met you without Ray. Thank you for all that you've done for me personally. And Lori and Stacey wanted me to give you a shout out. And good luck. And when you get the vaccine, tell us.
I'll let you know.
All right, buddy. Have a rockin' hot day.
Thanks, Howard. See you later.